So, good afternoon, everybody. We're trying a Monday webinar this time round. We've been doing them on a Friday up to this point, but we thought we'd change things up a little bit and see whether Monday will be more or less popular. So, thank you, everybody, for joining. I'm going to give my standard preamble and then get into some questions. So, the point of this webinar is for anybody out there to ask any questions about wills. It's a subject that most people don't have a lot of experience with. There's a lot of jargon, terminology that's used within the will writing process. And so if you have any questions, please feel free to throw a question into the chat. I'll work through those questions. We have had some that have been submitted to us over the last week or two, so I'll also take some of those. But yeah, I'm happy to answer any questions that anybody may have. So, a bit of a preamble. First of all, I will introduce myself. I am Tim Hewson. I am the CEO and co-founder of Legal Wills. And Legal Wills was started about 25 years ago. We're now in our 25th year. And it was founded by myself and Henry Roud. It came out of an understanding that there was a problem in that people all knew that they should be getting their wills written. It was an important document, and most people know that they really should have one, but nobody, or a lot of people, weren't getting around to getting it done. And so we realized back in 2001 that there were barriers to getting it done, and whether they were a financial barrier or getting it to the top of the to-do list or getting around to making that appointment with a lawyer, for whatever reason, most people weren't getting their wills written. So Henry and I thought there must be a better way. We started researching, we started working with some lawyers to see whether we could make the process more engaging, inviting, user-friendly, more fun even, to go through the process of preparing your will. And most importantly, trying to make it convenient and affordable. So there was really no excuse to not getting that document written. So it's important for me to say from the get-go that I am not a lawyer. I cannot give legal advice. Anything that I do say on this webinar, if I'm answering questions based on common knowledge, what I regard as information that's out there that you may not necessarily be able to find very easily. And oftentimes information that's out there can be confusing and contradictory. You may find information that's not relevant to your jurisdiction. For example, I know that a lot of Canadians try to find ways of structuring their estate and information, but may find US resources that don't necessarily apply to their situation. So I'm more than happy to answer questions that if you can say in the chat where you're located, I may be able to provide information specific to your jurisdiction and answer questions that you may find difficult to find the answer to, but I am not giving legal advice. I'm giving standard information that can be found available anywhere on the internet. So with that, I want to get into some of the questions. Let me just see, there are some questions coming in on the chat. Hello. Please feel free to drop some questions there, and I can get straight into it. So we're going to have about half an hour going through some of the questions. I know last time we really focused on the executive role and different concerns that people had about choosing an executor, what they had to do, how the most appropriate person, what if they didn't have somebody to name. So we really focused everything on the executor. I think this week there's no real theme. It's more just questions that have come in over the last couple of weeks and anything you can drop in the chat. So the first one I'm going to explain and discuss is how I can update my will and why I would need to. And the first thing I would say is, like, let's put aside updating. So let's talk about canceling a will. So you have a will in place right now, and it doesn't reflect your wishes. So there are ways that you can actually just cancel this document. And we would never recommend that you do this, because if you just cancel it rather than updating it, it means you don't have one anymore. And there's never a point in a person's life where you should be walking the streets and living your day-to-day life without a will in place. So, but you can cancel a will without just updating it. So the ways that it can be cancelled are quite simply to destroy it. You just shred the document. There should only be one original piece of paper that is signed in ink in the presence of witnesses. That is your last will and testament. You might have made copies, and any copy that you make should actually be marked as a copy, but your executor is going to need to work with the piece of paper that has your wet signature, they call it, an ink signature on it. So the best way to cancel a will is just to shred that document. It's a good idea to go around and find all the copies as well, if you made copies, and shred those too. But if you don't have a document that people can refer to, then you have effectively canceled that document. The best way to cancel your will is to actually prepare a new one. And any new will that has been written, and certainly anything that's prepared using our service, the first clause in any will that you go to any will writer is going to say, I hereby revoke any previous wills or testamentary depositions. So codicils, anything that you've written related to your will, a will or a codicil, anything that you've written previously, if you write a new will, it's going to automatically revoke any previous one. So as soon as you sign and date it, that is your current last will and testament. Any previous one is now no longer a relevant document. The other way, there's one other way that a will can be cancelled, and that is in some jurisdictions, if you get married. And if you get married, and let's talk about Canada, it's an interesting landscape there, because in Canada, I would say about half the provinces and territories will automatically cancel a will that you have written. On the day you get married, you now don't have a will anymore. So there are provinces that have done away with that law. There was a good reason for that. It's because there were predatory marriages that were happening. So you might get somebody who would marry a senior, and all of a sudden their will was no longer in effect. So they were able to take advantage of this fact that a will would automatically be cancelled if they were to get married. So some provinces don't do that. And I actually looked ahead of time. So BC, Alberta, Saskatchewan, Quebec, and recently Ontario just changed the law. So in those provinces, a marriage will not cancel your will. In every other province and territory, it will. In the UK, again, they just changed the law to say that does no longer happen. It used to. So they're the ways to cancel the will. So how do you update a will? So there are basically three ways to make a change or an update to a will. You could theoretically handwrite on that will. You could say, I've named my friend Bob Jones as my executor. I don't want Bob Jones to be my executor anymore. So you could scratch that name off and write next to it, Steve Green. But if you do that, you're going to have to initial next to that change, and you're going to have two witnesses. Also, watch you make that change, and also in each other's presence, the three of you are all going to have to sign to say that they saw you make that change, and all of the things that go with that. You weren't put under pressure to make that change. You had capacity to do that. In general, don't do this. Don't do this, because you're going to end up with a situation where you've then written over things, and then you might want to update the change that you previously made. And before long, you've got a document that's got scribbles all over it. It's very confusing. Nobody knows what you really meant. And hang on, is this witness to that change or that change? It's just a really scrappy way to make an update to your will. We never recommend it. So what happened years ago, when we used to type out all the wills, or we went to a lawyer who even hand wrote all the wills. But let's go back to somewhat recent times where your will was all typed out. And if you went back to that will writer and said, you know what, I want to change the name of the executor, can I just update my will? They don't want to have to type out the whole thing again. It could be 5-6 pages, and they just want to make that one change. So there was a way of doing this, and that's called a codicil. And what a lawyer would do is write one page that said, for clause number 3, when we talk about the executors, instead of Bob Brown, clause 3 should now read Steve Green. And this is a codicil, and that codicil would then be signed, and the witnesses would sign it as well. And then that document would then be attached to the will, and that would be the codicil to the will. It's still not a great way of doing it, though, because if you write another codicil and the codicil is referring to the other codicil, it can get very complicated. And the only reason anybody ever did codicils was to save the effort in typing out the whole document again. It was like a workaround to save on redoing it. So now we have computers, we have printers. Anytime you made a change, even if it's handwritten, like a scratched out or writing a codicil, you still need to get it signed and you need to get it witnessed. And that process is actually the most time-consuming part of the whole thing, especially if you're using a computer and a printer. So nowadays, the only way we recommend making an update to your will, even if it's a trivial update like changing the name of your backup executor, or you just want to do something slightly different, write a new will, prepare a new document that then hereby revokes the previous document. You have a nice clean copy, and then with that nice clean copy, you have to go through the signing process again, and sign it in the presence of witnesses. So yes, there are different ways to update it, but the way to do it always is to prepare a new document. Just looking at some of the questions that are coming in. So okay, so there's one about really a technical question about our service. I paid for the will, and when I asked to get a copy, all I got was lines on it, not the will itself. Please, right. So any questions related to how you have used the service and whether you've got what you wanted to get from the service, please contact us through our support team. We have a team answering phones. We have a chat bot, an AI chat bot, and we do have live people who are answering emails as well. Anything that's related to, I used the service, I didn't quite get what I wanted. It doesn't reflect my wishes, or I printed it out and I got blank sheets of paper. Please go to our support at legalwills.ca, support at uslegalwills.com, same legalwills.co.uk. Like, we have a team who can help you. So for this one, a few lines. So you didn't get the full document. That's definitely something that we would have to, somebody from the support team would look into the account, see if it works on our side, see if there's any issues on our side, see whether the will is complete, and we will be able to give you specific help for that particular account. So please get in touch with us, and you'll get an answer probably within the hour, and the answer will probably be a fix for it. So going back to why you might want to update your will. So I regard there as 3 situations where you might want to update your will. There's a change in your circumstance. So this change in your circumstance Um, could be a change in financial situation. You've had a child. You've got married, divorced. You've had a windfall. Something's happened in your life. You've moved to somewhere different. Um, there are things that have happened in your life that would make you immediately think, I should probably take another look at my will and update it. Another good reason is when there's a change in circumstance of somebody who you've named in the will. So you may have named a guardian for your children who may no longer be the most appropriate person to be the guardian for your children. They may have moved to Australia. They may have had triplets of their own. They may be serving time in prison. Right? They may be in hospital. There's a multitude of reasons why that person may not be the best person to now be the guardian for your children. So their circumstances change, and you want to update the guardianship appointment in your will. And that also applies to your executor. If your executor is taken ill and your backup executor is taken ill, you want to go in and update your will. And this really is one of the strengths of using an online service, where I know that there's people in a situation where their backup executor may not be the best choice anymore. And if you've written your will and gone through quite an expensive process where it took a lot of coordination to prepare your will with a lawyer, and you may think, it's not really worth going through that for the backup executor. I'll hold off until there's a few more changes. I really need to make the update. But if you do use an online service, you can simply just log into your account, change the name of your backup executor, print off the new document, and sign it in the presence of witnesses. You have your nice, clean document, and it reflects your true current situation. But there's also the other thing where you might want to update your will is you've just changed your mind. And you can do that, absolutely. And it could be falling out with somebody who's named as the guardian, or you've left a bequest to. So you might have left something to a person who is not as close to you anymore as they were. Then you might want to take another look at your will. And I think particularly with organizations, charitable organizations that are included in your will, there may be one that was important to you that's no longer as important, or a charity that you never really had much exposure to, but have suddenly had a major impact on your life, and you want to recognize that organization in your will. That would be a really good time to go in and review the distribution plan for your will, and certainly take another look at your charitable bequests, and see whether the charities are still reflecting how you feel about philanthropy and which organizations are important to you at that time. So there's some of the main reasons. Changing your circumstance, somebody else's circumstance, and just a change of mind. There are reasons why you might want to update your will. But always, if you are updating your will, absolutely just create a new document. So we just take another look at comments coming in. So this was a complicated one, and it's I'm going to put it up there. So what kind of encryption does the Vault and My Messages use? And in the event of a data breach, can my files be leaked? And I want to know if it's safe storing the login details to my password manager. Is it safe? So the final one's a slightly different one. Like the login details, I'm presuming the login details to the legal will service, whether you would include those login details in your password manager. And that really depends on the security and privacy and robustness of that password manager. We certainly, the single biggest exposure to the information that you put into our system is your own user ID and password. And if somebody has your user ID and password, now, having said that, we have two-factor authentication on login, either by email or by text message. We do have that. So you can certainly turn on two-factor, multi-factor authentication on login, and that's a very extremely important part of our service. Interesting, I think most online will writing services don't have that. We're kind of unique in having that, and that surprises me a little bit. If you choose not to use that, then your login user ID and password is the window into the service, because the data that's stored within your account doesn't exist as plain text data anywhere. Your will doesn't even exist as your will. Your will exists as answers to questions. And it's only when you log into your account, and as you log in, you decrypt or unencrypt that information, and your will only exists at the end when you say, click generate my will. And at that moment, the document is compiled, and you can then download that document as a PDF file. So if there was a data breach, and in 25 years, we've never had one, we do run very frequent third-party security assessments on our service. Obviously, security is paramount in our design and our philosophy completely. It's part of our DNA, if you like. The security of the information is very important to us. But if there was any data breach, nobody would be able to see any documents. We don't store documents. They're all encrypted, and your will only exists as a document when you click that button to generate the document. There are two exceptions to that. We offer a service where we can print and ship the document to you. If you do that, you then enable somebody in our support team to also be able to click and generate that document as well. And we also provide a service where we offer a legal document review by an estate planning attorney, a will writing specialist. And if you do that, again, that person can then log into their account, and they will be able to view these requests to have the document generated and reviewed. And just one clarification on that. I'm storing the login details to my password manager account in the vault. So I do. It is encrypted. It is secure. The only people who will be able to see it is somebody who's logged in with your user ID and password, or a key holder that you have designated as somebody who can log in and view that document. And the key holder is given like a 25-digit random string, and that's their unique key holder ID for getting into to view these documents. Absolutely. So this is one of the challenges with digital assets in general. And digital assets can mean a multitude of things, but one of them is the handling of your online accounts. Who is going to take responsibility for not just your LinkedIn account, Facebook account, things like that, and manage those, but also potentially real assets like PayPal that has financial assets in them, your Shopify, YouTube revenues, things like that. So there could be things with actual financial value, and giving somebody access to get hold of those is one of the great challenges with digital assets. So we do suggest that you somehow convey to your executor and your loved ones how they can access those online accounts. And I don't know of a better way of doing it than using our Vault, the My Messages service, or even our LifeLocker service. They're really good ways of doing it because they do have a key holder mechanism. There's protections around premature access to that information as well, and it is all encrypted on the server. So I don't actually know of a better way of communicating that kind of information to the executive and to Um, so this is an interesting question. So what actually happens when I die, and like how does the will work? What happens? Um, so there's some key elements to this. Um, Firstly, your executor needs to know that they're the executor, and they need to know where the will is, and they need to have access to that document. So the moment you die, that the executor's role kind of springs into action. They have to start to do things, and first thing they need to do is locate the will, the last will and testament. I guess one of the key things is to verify that it is the document that they're going to be working with, and they are still named as the executor, and you didn't, for some reason, scratch out their name and write another name and have that change witnessed the way I said you shouldn't. We have to assume that they then get that document. Okay, I am the executor. I now have responsibility. So the first thing that executor should be doing is then communicating with the family and the loved ones to say, it's a sad day. Tim's died. I am the executor. I have his will, and I'm now going to start taking responsibility. That taking responsibility means starting to assess what your assets are and starting to secure those assets. What we don't want to see happen is people logging into accounts they shouldn't be logging into, taking things that were verbally promised to them that aren't written in the will. This happens a lot. That families suddenly they get over the grief and then start thinking about, oh, hang on, I was promised these things. I think I'll go and get them before anybody else does. So the executor has to immediately start to secure those assets and start to take an inventory of everything that has value, and particularly things that are written into the will. There may be specific things written into the will that are supposed to go to a particular individual. So then we have a whole checklist of what that executor has to do. But once they've started to secure those assets, then they have to go through a process called probate. They have to submit that will to the probate office, and that process is going to allow them to, firstly, it's going to validate and certify that document, everybody agrees that is the last will and testament, that's the one that everyone's working with, that is going to be officially recognized as the document that is Tim's last will and testament. And within that, okay, this person's been named as the executor, and the probate office is going to give them a grant of probate. The grant of probate is a court-issued document that is going to allow that executor to start going to the banks, going to the financial institutions, and starting to gather up your assets. They will probably open a bank account for your estate and start to put things into that bank account. So the funeral has to be done as well, and there's a lot of things that are involved. And we certainly do include. There's two things that we do actually at Legal Wills. When you name an executor, we actually allow you to notify the executor that they've been chosen and they've been named in the will. And we also allow you to send them a document that we've created, which is a full time frame of everything that executor should be doing at different stages of the process. So from the immediate day 1 to 3, and organizing the funeral, things like that, that's an executor responsibility, working with the funeral home, through to probate and filing your taxes with CRA and doing a evaluation of the estate, which is required for that tax return as well. So there's a whole slew of things that need to be done, and that whole process can take a year, can take 18 months, can even take 2 years to get everything done. but there is immediate thing that needs to be done, and then there is the, um, the things that need need time to flesh out. I would also say another part of that is if you're a beneficiary and you know you're a beneficiary of a will and you've not heard from the executor yet, and it's like, man, that person died like 10 days ago. I haven't received anything yet. It takes time. It really takes time. So don't fret. Like if it's been a year, maybe you might want to, the executor should be keeping you in the loop. It is a process for talking to the family and the loved ones and letting them know what's going on. But it's not something that you're not going to suddenly get a check in a week. It's going to take months, if not years, for everything to be going out to the beneficiaries. Okay, so with that, I'm going to just touch on this one here. Does my spouse and I each need our own will? And what about a power of attorney and a living will? So, yeah, I'm going to maybe we'll end on this one. We've gone through half an hour. These were long-winded answers. I'm really sorry. It's usually a little bit snappier than this. But hopefully the information has been useful if you were interested in those particular questions. So I think we may have touched on this before, but this idea that one document can serve two people. This is what is known as a joint will, and it used to be popular a generation ago when there was a feeling that perhaps only one member of the household truly owned the assets in the household. Everybody else was like supporting members of the family. So there was a sense of we don't, my spouse doesn't actually own their own assets outright. It was a kind of like a 1940s, 50s view of how the family worked. Certainly changed. It also used to save a bit of an effort in, again, this typing out two documents that kind of said pretty much the same thing. Like if I die, it goes to my spouse, and the spouse dies, it goes to me. And if we're both involved in an accident, then it's going to go to the children. There was a sense that you could maybe collapse that all into one document, so we didn't have to do two. These were joint wills, and they're problematic. They become an issue once one person's died, and then the other one wants to move on, and then they remarry. But then there was a will that kind of talked about certain assets and how certain assets were going to be divided. And you can actually create a will. It's called like a mutual will, where you're actually bound by the terms in that first one. You can't even revoke that joint will. And some people say in the joint will, we promise to never write a new will or something like that. And this is just like old school thinking, and we don't do that anymore. What we do now is certainly a married couple needs to have their own individual wills, and each will would typically name the spouse partner as the main beneficiary. You can certainly have your own nuances within there. You could have a charitable bequest in yours that's not in the other one, certainly. But fundamentally, the main beneficiary is the same. And sometimes even the executor can be each other as well. And this is what we call a mirror will. Like mirror, you're looking in a mirror because they reflect each other. And each of these documents has a plan in case the spouse doesn't survive the other one. Or you're both involved in an accident at the same time, then both of these documents have, and if my spouse doesn't survive me, then this is going to happen instead. And there's a sense within these documents that you both have your own assets. You do, obviously, you have joint assets, but if you were both involved in an accident at the same time, those joint assets would be regarded as half each, and you'd have oftentimes the alternate distribution plan is the same. It's going to go to the children. But you could have a mirror will where in a blended family where one of you may have biological children where the other one doesn't. And so your alternate plans could actually be different. So it's mirror will is a kind of a concept rather than a legal contract between those two documents. We offer mirror will services. We have a couples package, makes it affordable as well. I would just touch on the power of attorney and the living will. So the living will is easy, right? Because you couldn't have a joint living will, because a living will is your wishes for the kind of medical treatment you would wish to receive if you were ever in a coma or in a irreversible terminal condition. This is the way I want to be treated if I'm in a vegetative state. You wouldn't have a joint document. You could have very, very different ideas for how you want to be treated. You could absolutely name each other as your decision maker, your substitute medical decision maker. You can name each other, but your wishes are likely to, they may be the same, they may not, but you wouldn't put both of those in the same document. And for the financial power of attorney, again, you wouldn't have a joint power of attorney. Oftentimes you would name your spouse as your financial power of attorney. So if something happened to you, your spouse can actually do things with your assets, and even do things that require both signatures on your joint assets. If your spouse has the power of attorney, then they would be able to sign on your behalf if you were unable to sign for yourself. You had dementia or you were incapacitated, then those joint assets that require both signatures, your spouse will be able to do that. Doesn't make sense to have a joint power of attorney. We don't even do mirror powers of attorney. You would each create your own documents. So with that, we got through like 4 or 5, ran a little bit over. Please, at any time, I'm going to just throw up my contact information at the end. Again, you can reach me directly, tim@legalworlds.ca. I'm more than happy to answer any questions you have. I do answer every question that I receive, even if it's to say, sorry, I can't help you, but I can refer you to somebody who can. I'm happy to do that, but I may be able to answer your questions directly. With that, I really appreciate you tuning in, asking your questions, and this will be available for playback on our YouTube channel as well. So thank you, and I'll see you